Well, this is great. So we can see the participants' names. There's no privacy on this. Well, I guess you can change it. But it's good to see some familiar names.
Okay, so I guess let's start. Good morning, bom dia a todos e a todas. Welcome to the Global Congress. I am Mariana. I am the director of Internet Lab. That's a think tank based in São Paulo, Brazil, that works on issues related to law and technology. And I'm the leader of the Internet Policy track of this Global Congress. We're on the last day of the Global Congress and finishing after a very intense week. So I take this opportunity to thank you all for your participation until here. And let me remind you that we have simultaneous translation to English, Portuguese, and Spanish, and that you can ask questions at any point through the Q&A tool below, and I will try to have them addressed after the initial presentations. So I'm delighted to be here again, and particularly this is the first time that we have an internet policy track in this Congress, and there's an important reason for we to have it. It's of course no novelty that the internet and digital technologies have been causing an enormous impact, especially in the field of copyright and in the other areas of IP as well. But more recently, many of the conflicts around copyright have revolved around digital platforms, which have enormously developed over the last years and have been performing new roles around new business models, sometimes taking the place of old businesses, sometimes impacting how other businesses and stakeholders work, but without substituting them, and sometimes performing new roles altogether. And this has all become especially important after the approval of the European Union Copyright Directive, which of course covers a range of subjects, but has become known worldwide due to the controversies around what became the Articles 15 and 17 that establish either new rights or change copyright liability regimes in respect to digital platforms. And then on the one side, we speak of an economic dispute between the tech sector and the content sector, let's say, but on the other side, and I guess this is what we're interested in this Congress and in this community, we're discussing policies that affect citizens concretely, their access to knowledge and information. And of course, the reason why we're talking about this here in this Congress that's dedicated to discussing bridges between IP, the public interest, and COVID, that potentially address many of the concerns around the world on disinformation, the crisis of democracies, and the health crisis more concretely. So in this panel, we'll be speaking specifically about the so-called protection of press publications, which was adopted solution for journalism in the digital environment, or an attempt to reach balance in an information world that's being read as imbalanced. Journalism, of course, which is essential to a democracy to inform the public, hold the powerful to account. And that's also going through economic distress with newsrooms shrinking all around the world. I guess the question is copyright the solution? Most of you will have heard that the European Union Copyright Directive, of how it created a new right for press publishers and how it was for a while baptized the link tax. It ended up incorporating part of the criticism it attracted. I think most of you will have heard by now of how the Australian government is also pushing for somehow similar provisions, how Facebook has been reacting. Maybe not so many of you will have heard that in Brazil, in the context of the discussion of a bill to fight disinformation, a similar proposal has been put forth by broadcasters mainly. And after that, an independent proposal was also made in the Senate. And in Latin America, Latin America as a whole, different countries are starting to discuss this too. To discuss the controversies around it and help create a critical mass, we have invited 3 panelists who have been dedicating to this subject for a while. So we have Julia Reda. She's a German researcher and politician. She was a member of the European Parliament for Germany from 2014 to 2019. And as a member of the European Parliament, she was one of the lead negotiators of the EU Copyright Directive. Welcome, Julia. She now leads the Strategic Litigation Project Control Copyright at German Fundamental Rights NGO, Gesellschaft, Society for Civil Rights. Neil Nitanel is a professor of law at the UCLA. He teaches and writes in the areas of copyright, free speech, international intellectual property, and telecommunications law and policy. And he's been doing research and writing about the press publishers' rights, particularly lately. Rob Nichols is an associate professor in business law at the UNSW Business Law and the director of the UNSW Business Business School Cybersecurity and Data Governance Research Network. And he's been also working on this subject also in the Australian context. So I will immediately give the floor to Julia. Julia, first, thank you so much for accepting this invitation. And I'd like to listen from you. What's your take on this problem? And a researcher in this field, and I understand you also have questions on whether this is a copyright problem or not. So the floor is yours. Thank you so much.
Yes, thank you very much, Mariana. As a German politician, I feel a particular responsibility to talk shortcomings and problems, especially in this context of disinformation. It is being discussed in Brazil right now. So first of all, though, since I'm kicking off the panel, I want to briefly describe why or what was the problem that publishers were trying to address when they first started pushing for this law, which was all the way back in 2009 in Germany. So the argument goes that large search engines in particular, but online platforms more broadly, especially Google and its Google News service, have been making enormous profits on the backs of the content produced by publishers. So the German press publishers were claiming that basically by listing very short parts of news articles and linking to them as part of search results or the Google News service, Google was extracting value unfairly from the publishers and what was not sharing it with publishers. And the solution that was proposed for that was to make the press publishers themselves holders in a new right. So, of course, news articles are already protected by copyright, and most of the time, this copyright is exclusively assigned from the author, the journalists who have written the piece, to the publishers. So that means that in most cases, publishers are already able to enforce the copyright in the news articles. But what was limiting what the publishers were trying to do here is that copyright, of course, does not apply to single words or individual sentences that don't have originality. In order for something to be protected by copyright, it has to be showing some kind of essence of the person's creativity that created something. So usually a single sentence or a newspaper headline would not qualify for copyright protection. And most of the time, that is all that search engines or social media platforms would show. The headline, sometimes a small thumbnail image of the main picture that was going along with an article, and a few sentences. So that means that this new neighboring right would give the press publishers the possibility to forbid even these relatively small extractions of content from news articles. So that's the purpose. That's what the law is trying to achieve. And the narrative on the side of the publishers was that having this exclusive right would basically give them the opportunity to negotiate with platforms for payment, basically for the privilege to be able to link to the news articles with some content attached to it. So I want to briefly address why I think this neighboring right does not really solve the problem, and why the analysis that is underlying this right doesn't actually get to the core of what is ailing the news industry. So I think everybody who has followed the discussion on the European law is aware that I have been a very strong critic of the neighboring right, but this is not because I don't agree that Google and Facebook in particular have really hurt the news industry. It's pretty clear that as these platforms have grown in sizes and in strength of their revenues, the newspaper publishers' revenues have really been going down. What I disagree with is the mechanism of why this has happened. It's not because search engines or social media like Facebook are able to somehow use the content for free. Actually, it's pretty clear that the publishers benefit from being listed in search results and on social media. Every newsroom, I think, in the world is nowadays hiring search engine optimizers and social media optimizers who are trying to make the content more attractive for the algorithms that are selecting what gets shown on search results, such as Google's. So the problem is really not that the platforms are taking the newspaper content for free and are not paying for it. The problem is that the platforms have fundamentally changed the advertising business model that a lot of news were based on. So traditionally, newspapers have been financing themselves through a mixture of subscriptions, classified ads, which have pretty much been destroyed by the internet, because you can now sell your bike on Craigslist or eBay for free. You don't have to take out an ad in the newspaper, and advertising from businesses. And this advertising from businesses is now to a very large extent taken over by platforms such as Facebook and by Google's advertising business, because those platforms have the opportunity to tailor the advertising to the particular interest of individual users. And they do so through the mass aggregation of personal data. So really, to a large extent, this is a data protection problem, that there is not enough regulation around what large companies are able to do with personal data, and are therefore at a huge advantage if, like Google or Facebook, they have the possibility to gather personal data of billions of people. But it's also, I think, beyond that, a question of where you are able to place advertisements. So if you are making a search for a particular search term, that is a much more attractive advertising environment for advertisers that are close to what somebody is searching for than placing advertising next to a news article. So it is true that Google and Facebook have fundamentally hurt the business model of newspapers, but it's not because they have been using their content for free, but rather because they have completely disrupted the advertising market that newspaper publishers rely on, at the same time that subscription and revenues from classified ads have also gone down. So that has really put a lot of publishers into crisis. The problem is that the neighboring right does not solve this problem. The neighboring right does give publishers the possibility to charge for basically linking to news articles, but it doesn't solve the fundamental problem that they actually want to be linked by Google and Facebook. So this puts them in a very weak negotiating position, and the price that they can expect to be paid for this linking by those large platforms tends towards zero. At the same time, it does put in place a lot of friction, a lot of transaction costs, because of course there are a lot of other news aggregators that aren't Google or Facebook, that are much smaller websites like Reddit is still pretty big, but in Europe, we have much smaller equivalents of those websites, small independent search engines that do not have the same negotiating power that Google has. And so when this law was introduced in Germany, the end result was that Google was given a free license by publishers to keep using those news snippets, because it's very important for the publishers to show up in Google search results, but smaller competitors were not given a free license. So this law that was designed to somehow limit or push back the ascent of Google has actually contributed to the dominant market position of Google by making the business of smaller competitors harder. But I think perhaps the much more important effects are those on smaller media companies and those on citizens. In the case of small media companies, you have the problem that actually the smaller a newspaper you are, the more you rely on links from third-party aggregators. Before you had Google search, before you had social media, people would usually get their news from a relatively small number of trusted news sources. So they would, if they use the internet at all, they would go straight to the landing page of the newspaper they trust. And this is, of course, extremely beneficial to the largest newspapers in the country. So it's no coincidence, I think, that the neighboring right was first lobbied for by the company that owns Germany's largest tabloid newspaper, Axel Springer. So basically, they are not particularly interested in having news aggregators at all, because news aggregators diversify the news sources that users can learn from. And this benefits small publishers and hurts the big brands. So in effect, the neighboring right actually contributes to media concentration by making it harder to run a news aggregator and to give people access to diverse news sources. In the context of disinformation, you could say, well, that's a good thing. People are going back to the big trusted brands that may have their problems. I mean, I can tell you that Germany's largest tabloid is not known for quality journalism or for having been particularly tough on disinformation. But at the same time, you may say, well, it kind of reduces the number of news sources that we don't know or something like that. But of course, disinformation websites that distribute disinformation deliberately usually do not rely on advertising revenue to do so. If you run a disinformation website purely for the purpose of making money, there might be better ways of doing that. But a lot of disinformation may be funded by certain autocratic governments. Like Russia today is not suddenly going to start charging people for linking to their websites, because they actually want as many links to go to those news articles as possible. So you're likely going to create an effect where honest news sources that rely on revenues may start enforcing this neighboring right, but disinformation websites that don't rely on those revenues are not going to enforce it, which means that it's actually going to be easier for platforms to distribute disinformation than to distribute trusted news. So I think also from a disinformation perspective, this is a really bad idea. And I think the reason why some publishers want it anyway is because it's primarily the really big publishers that are pushing for this, that hope to benefit from the media concentration effect that this proposal has. That is not to say that we shouldn't do anything to help publishers in this extremely difficult economic situation. So I'm really looking forward to also discussing some of the alternatives that might be out there for taking some of that advertising revenue that Google and Facebook are currently raking in and redistributing it to support quality journalism. I just don't think that copyright is the tool to do so. and that actually using copyright to try to solve problems that are really about the advertising business model is likely to be counterproductive and make some of the problems worse. I'm going to stop there.
That's really great, really clarifying, Julia. I think both about the process, about what's happened in Germany, and your position on what has not to be done. And I'd like to hear from Neil. First, what he thinks about the points made by Julia, but also, Neil, I understand you've been doing research and writing about alternative solutions. So I think this copes really well with Julia's presentation. The floor is yours.
Okay, great, thank you. Yeah, I've got a forthcoming law review article called Mandating Digital Platform Support for the Press. And my talk today will draw on that article. It's still very much in draft, so I look forward to the discussion and including any comments or suggestions that anybody would have. So firstly, I agree with everything Julia has said about the Article 15 press publishers' rights. Granting news publishers a neighboring right is the wrong approach. For the reasons Julia laid out, it's likely to be ineffective, it's going to contribute to media concentration, and it doesn't address the primary causes of news publishers' dire financial straits. So simply put, the major digital platforms do not harm news publishers by using news content in a way that should implicate copyright or neighboring rights law. Rather, the platforms harm news publishers in two other ways. First, as Julia mentioned, Google and Facebook enjoy duopoly control over the digital advertising market. As such, those platform giants devour the ad revenue that has long been the financial lifeblood of the commercial news media. Secondly, the major platforms serve as the primary gateways for online news readers. And in doing that, the platforms significantly erode news publishers' brand recognition and user loyalty. So there's no magic silver bullet, I think, that will remedy these harms, but I will offer two kind of categories of proposals that I think would help support the types of journalism that numerous commentators have observed are the most critical for democracy, and that's investigative journalism and local affairs reporting. So I will say, I'm as a US law professor, I'm writing primarily about the United States. But I both draw upon the experience of other countries, and I think my proposals merit consideration outside the United States as well. So first, a couple of words about digital advertising and the impact in the United States. As duopolists in the digital advertising market, Google and Facebook both compete with news publishers for advertising and act as digital advertising brokers for news publishers and advertisers. And in doing that, they take up to 70% of the revenue from advertisements placed on news publishers' websites. The impact on journalism has been nothing short of catastrophic. In the United States, through the end of the 20th century, most newspapers earned about 80% of their revenue from advertising and only 20% from subscriptions. But between 2005 and 2018, newspapers' advertising revenue plummeted by 72%. That's from $50 billion a year to an estimated $14 billion a year. Much of that decline coincides with Google's and Facebook's ascending duopoly control. From 2014 through 2018, Google and Facebook's combined US digital advertising revenues increased by an astonishing 150%, from $30.5 billion to $77.8 billion. During the same period, newspapers suffered a 35% decline in advertising revenue. And quite tellingly, moreover, from 2014 through 2018, US newspapers suffered a 12% drop in digital advertising revenues, even though unique visits to newspaper websites increased by 41%, and as newspapers' digital advertising revenues came to be an increasing percentage of their total advertising revenues. So the bottom line, I think, is that news publishers cannot compete with the dominant digital platforms in the digital advertising market, and that the days that advertising represented a reliable long-term source of funding for journalism are over. So as a partial solution to this problem, and again, agreeing with Julia that intellectual property rights are not the right approach, I propose that, and again, this is a proposal within the United States, but perhaps it is applicable in other countries as well. I propose that the United States government impose an excise tax of 2% on digital advertising revenue earned in the United States, with the tax proceeds earmarked for the support of investigative and local journalism. Digital advertising companies that earn less than 5% of total domestic digital advertising revenue would be exempt from this excise tax. So it's only focusing at the major companies. At this point in time, that tax would apply to the digital advertising revenue earned by Google, Facebook, and Amazon. In 2019, the combined US digital advertising revenue of those three platform giants amounted to just over $1 billion. So a 2% tax on those revenues would yield about $2 billion per year. Now that sum pales in comparison to the advertising revenue losses suffered by US newspapers in the last decade. But it's about 4.5 times Congress's current annual appropriation for the Corporation for Public Broadcasting. And $2 billion per year is also many times larger than the sum that Google and Facebook have pledged to contribute to support local journalism in the United States. So those two dominant platforms have promised to contribute a combined total of $1 billion, which would be distributed incrementally over several years. And under my proposal, the digital advertising tax proceeds would be deposited in what I label the Fourth Estate Trust Fund. The trust fund would allocate half of the proceeds to original investigative journalism and half to reporting on local public affairs. As I detail in my article, mechanisms would be put into place to ensure as much as possible that the trust fund would be managed free from undue political influence, and that the funds would be distributed to legitimate professional news organizations. And I would argue that both commercial media like the New York Times and Washington Post, as well as nonprofit newsrooms like ProPublica, would be eligible for investigative journalism funding. But for reasons I discuss in my article, funding for local reporting would be allocated entirely to the Corporation for Public Broadcasting for distribution to nonprofit, publicly owned local TV and radio stations, which in turn could collaborate with nonprofit news publishing sites. So my proposal for a digital advertising tax has some rough parallels in other countries. So for example, since 2018, France has levied a 2% tax, colloquially called the YouTube tax, on revenues earned by online video on-demand providers by distributing content in France. And France uses the tax proceeds to help fund the production and promotion of French cinema. Germany recently imposed a similar tax in the amount of 2.5% to subsidize German video production. And a similar tax has been proposed in South Korea and Poland as well. And several European countries have also imposed or are considering imposing taxes of between 2% and 5% on revenues attributed to providing digital services in those countries, including on digital advertising revenues. For the most part, those taxes are meant as general revenue producing measures, and I will say that they have met with the staunch opposition of the United States. All right, as I mentioned earlier, the loss of advertising revenue is not the only way that I think digital platforms are harming the press. In addition, as the primary gateway to online news readers, digital platforms are usurping news publishers' historic role as news curators and are undermining news publishers' brand recognition and news readers' loyalty to any single news outlet. So studies show that when users reach a news site, a news website through a search engine or through a social media news feed, most users cannot remember the name of the news publisher after their visit. That undermining of brand recognition has some important consequences. News organizations rely on brand recognition to attract new audiences and to build a core of loyal paying subscribers or contributors. Brand recognition provides an important incentive for investing in breaking news stories and in quality watchdog journalism. Indeed, since investigative journalism is expensive, risky, and rarely profitable, its primary benefit for both news organizations and individual journalists lies in building reputation and brand awareness. News organizations, I think, are less likely to invest in socially valuable investigative journalism if they are not able to capitalize on it to stand out from their competition. And that's true for nonprofit newsrooms as well as commercial media. Nonprofits also need to attract loyal readers and donors. All right, so in my article, I offer a number of proposals that would require digital platforms to help news publishers maintain brand recognition. Firstly, platforms should be required to prioritize original reporting. In particular, all major social media and newsfeed aggregation sites should be required to identify and give priority to original reporting among the news stories on a given topic provided to a particular user. So in that regard, there are online news aggregators that regularly summarize and rewrite original reporting. And that's absolutely fine in principle. There should be a free flow of information to online readers. No news publisher should have the right to prevent others from summarizing or rewriting news stories. But at the same time, derivative news aggregators that rewrite original reporting undermine news publishers' investment in expensive investigative journalism. So I think at the very least that platforms should be required to give greater prominence to original reporting over derivative news summaries and rewrites in their news feeds. In fact, under pressure from news publishers, Google and Facebook have both announced plans to adjust their algorithms to prioritize the original news publisher sources for any given news story over news aggregators that rewrite the original reporting. So my proposal would codify and extend that practice in regulation. But going beyond that, I argue that major digital platforms should be required to display links to original reporting. FTC regulation should require that social media sites like Facebook feature original reporting on topics of interest to the user, even if the user has not chosen to follow that particular news outlet that is the source of the story. So that regulation might require, for example, that for every 5 items of sponsored content that appears on a user's newsfeed, Facebook must include 1 reference and 1 link to original reporting on a topic that the Facebook algorithm has identified is of interest to that user. In other words, Facebook should be required to alter its algorithm to generate original reporting of likely interest to the user, not just micro-targeted advertising in Facebook's newsfeed. And then finally, news publishers of original reporting that are listed on a major digital platform or newsfeed site should have the right to require that the listing include a link taking the user to the newsroom's own website to read, view, or listen to the story, as the case may be, as well as, if the news publisher wishes, a prominent indication of the news publisher's trustworthiness rating by a third-party media watchdog of the news publisher's choice, with a link to that watchdog site. So platform and news feeds like Apple News and Google News have every interest to keep users on their own sites. But the public interest in facilitating newsrooms' ability to build brand awareness, I think, should take precedence over that. right? So again, newsrooms should be able to require that the platforms include a link that will take users directly to the newsroom's website and not keep them on the platform's website. All right, so those are my proposals. I welcome our further discussion.
Thanks, Neil, for that. I like it very much that you come to this talk with concrete proposals. And I imagine there would be important questions, of course, about the specifics of it. I think we'll have some time to discuss and encourage participants also to place questions. But I would like now to give the floor to Rob Nichols. Rob, besides your experience with internet governance and particularly the interaction of platforms and legacy media in Australia, you have been following this discussion, right, in Australia closely. I understand, sorry, it's noisy. I understand you have your views on this issue too, arising from how you see the landscape from there. So thank you also for being here, and the floor is yours.
Thank you, Mariana. So my research focuses on competition law and policy. It's also in a far off land where it's about 25 to 3 in the morning, which sort of poses the question, why am I on this panel at all? And the answer is that Australia has taken a competition law approach in looking at the bargaining, or more accurately, the refusal to bargain between the Alphabet businesses and the Facebook businesses on one side and news media businesses on the other. The imbalance of market power creates a competition problem. Now, I agree with Julia's analysis on the crisis for legacy publishers. The competition law approach doesn't solve this crisis any more than a copyright law approach does. In Australia, as in most other jurisdictions, competition law protects competition. It does not protect competitors unless there's an abuse of market power. So what I'd like to do is to give you a bit of history as how we got here in Australia and what the position is. I'll also try and give you my best guess as to the legislative outcome that will occur within the next 5 weeks. As is common, at least in Australian politics, the current situation was driven by a political deal. A now former senator called for an inquiry into the relationship between the platforms and news media businesses. In return, he offered support for changes to the federal government's media ownership laws. The deal was a reduction in media plurality in return for an inquiry. And in December 2017, the Australian Competition and Consumer Commission, or ACCC, was directed to consider the impact of digital platforms on competition in the media and advertising services markets. This was known as the Digital Platforms Inquiry. The fact that there was a direction increased the information gathering powers of the ACCC compared to self-directed investigations. The ACCC examined the implications of these impacts for media content creators, advertisers, and consumers, focusing in particular on the impact on news and journalism. So the inquiry was kicked off in December 2017. The ACCC issued an issues paper in February 2018. There was a preliminary report in December of that year, and the ACCC issued approximately 60 statutory notices. That is a requirement that particularly Facebook and Google provide information, and also had a range of public forums as part of the inquiry. The final report was made public in July 2019. In July 2019. That report made 23 recommendations. Only one of these recommendations looked at the platforms and news. Most of the suggested reforms were aimed squarely at countering the dominance of Facebook and Google, described by Julia and Neil, which the ACCC said had distorted a range of markets, including in advertising. The ACCC report found that Google and Facebook have substantial market power in their respective domains of web search and social media. In Australia, it's not unlawful for firms to have this degree of power. There's no trust-busting law here. However, it does mean they're likely to be subject to the misuse of market power law. The ACCC was concerned that current merger laws don't go far enough, given large platforms' ability to remove future competitive threats by simply buying startups outright. The ACCC, like many other inquiries that were published in the last 18 months or so, worried that killer acquisitions could entrench a platform's market power. Now, of these 23 recommendations, the government supported 6 in their entirety, 10 in principle, with plans for further reviews, which haven't yet started. It noted 5 others and rejected 2. One of the rejected items was a proposal, not inconsistent with Neil's, that philanthropic funding of journalism should be tax deductible. That was rejected. The other rejected proposal was a mandatory takedown code to assist copyright enforcement against digital platforms. Instead, the government made a commitment of about 15 million euros over 4 years to fund a new unit in the ACCC to try and look at some of the issues associated with competition and consumer protection in digital platform markets, and in particular, how the ad tech sector works and other competition issues flowing there. The key issue for today was the ACCC's proposal to have a voluntary code of practice regarding the power imbalances between digital platforms and news media businesses. A voluntary code means that the industry has the opportunity to develop the rules itself. The government directed the ACCC to work with stakeholders to develop and implement a voluntary code to address the power imbalance, and the ACCC was tasked with providing a progress report on code negotiations in May this year for a voluntary code to be finalised in November. Back in December last year, the government reserved the right to impose a mandatory code if agreement wasn't reached. The code was based on tech giants enjoying the benefit of news media businesses' content without paying for the privilege, which we've heard from. The ACCC was particularly concerned about fast loading versions of news business articles that don't display the full range of paid advertising that appears on the news website's own pages. The ACCC report showed the issue that Julia raised, that media companies' share of advertising revenue has dropped by a factor of 50% over the last decade as advertisers flock to Google and Facebook. Not terribly surprisingly, there wasn't any agreement between Facebook, Google, and the news media businesses, and a mandatory code process commenced. Now, Australia's decision to abandon negotiations in favour of mandatory rules contrasts to the situation that's currently playing out in France, the European state which has perhaps the most advanced implementation of similar policy, but flowing from the EU copyright directive. In April, France's competition regulator ordered Google to negotiate in good faith with publishers on remuneration for the use of content. Any agreed compensation would be backdated to October 2019, when the directive became law in France. Google's previous solution had been to require that publishers license the use of snippets of their content to Google at no charge. But France's watchdog argued that this was an abuse of Google's dominant position. On Thursday of this week, yesterday for most of you, 2 days ago for me, a French appeals court confirmed that Google must open talks with publishers in France about paying to use their content. This ruling compels Google to sit down with publishers and news agencies under the neighbouring right that Julia has described. This would allow publishers to demand a fee from online platforms for showing the news snippets. The competition regulator, the Autorité de la Concurrence, had previously prohibited Google from simply not showing snippets. Isabel de Silva from the Autorité told Reuters it's a world first for such a case. All competition authorities like to claim everything is world first, including Australia, and that the decision had validated the previous decision by the competition authority. Now, on July the 31st this year, the ACCC released the draft mandatory bargaining code. It allows news media businesses to bargain collectively or individually with Google and Facebook for payment for news used on platforms. And to be eligible, a news media business must have employed journalists and earn more than about 90,000 euros a year in revenue. The draft code, so no citizen journalists. The draft code doesn't specify how much news media businesses should be paid. Instead, it provides a negotiating process in which Google and Facebook must take part. The negotiating phase lasts up to 3 months and includes at least 1 day of mediation. If there is no agreement, the process moves to compulsory arbitration. The arbitration panel selects one of the final offers of the parties. This is a process that's sometimes called baseball determination. The arbitrator can pick one or the other, but nothing in between, and the decision is binding. The range of Facebook services subject to this arbitration include Facebook Newsfeed, Instagram, and the Facebook News tab. The Google services are Google Search, Google News, and Google Discover. WhatsApp and YouTube are not included. The draft code introduces a requirement for Google and Facebook to give 28 days notice of any algorithmic change that will either affect referral traffic to news or the ranking of news behind paywalls. And this goes, I think, some way towards one of Neil's proposals. There's also an obligation on Google and Facebook to give businesses, news media businesses, clear information about the nature and availability of user data collected through users' interaction with news on the platforms. It doesn't mean that Google or Facebook must share the data itself, which Google and Facebook have, of course, claimed, merely what the nature of that information is. Now, a breach of the code is significant. Going to have a couple of outcomes. The first is an infringement notice. It's like a speeding ticket. It has a penalty of about 75,000 euros for each breach. However, if the ACCC takes one of the tech giants to court, the maximum penalty is the higher of about 6 million euro or 10% of the platform's turnover in Australia in the last 12 months. The draft code was open for public comment until the end of August. The final version will be considered by Parliament in October and November. In response, Facebook has threatened to exit the provision of news links in Australia. Now, the anti-discrimination arrangements in the draft code means Facebook has threatened to exclude all news, including international news. It was a big issue in Australia. but it's got a little bit weakened in the last week or two, given that Facebook has also threatened to exit Europe over Schrems 2, threats to exit have become less credible. Google has used search warnings, YouTube warnings, and a comedian to elicit public support in opposition to the draft code. It's not had a general uprising of the people in favor of Google as a result. Now, it's likely that the final version of the code will accept some of the issues raised by each of Facebook and Google. The algorithmic change notice, the time of the notice is likely to change. There's likely to be clarity to reinforce the points made by both Julia and Neil that the financial relationship between the platforms and the news media businesses is symbiotic and the value flows are bidirectional. The arbitration process may change. However, the requirement for there to be recognition and an understanding that the value of creation is likely to be greater than the value of curation will continue in the final version of the code. It's got bipartisan support, and in my view, and because of that bipartisan support, a version's likely to be law by the end of November. And that's an update on where we are here, and I'd be happy to both pass back and to answer any questions.
Thanks a lot, Rob. That's really helpful. We do have a question arriving, but before that, I'd like to give the floor to you again so you can make comments on each other's presentations, because I can imagine that they provoked you in different ways, if you wish, of course. So I'll give the floor to Julia, Neil, and then Rob for 5 minutes each for their remarks.
Sure. A comment and perhaps a question to Rob. If I understand the situation in Australia correctly, is that unlike France, this approach relies entirely on competition law without actually changing copyright law at all, which I find really interesting because, of course, France has been trying to address the shortcomings of the neighboring right as it has been implemented in Germany, and indeed in Spain. We didn't talk about that. So Spain also tried to introduce the neighboring right, and they saw the experience in Germany where Google had been given a free license. So they made this neighboring right unwaivable, which meant that newspaper publishers were required to charge money for it. Which led to Google shutting down Google News in Germany, but I'm sorry, in Spain. But I think the biggest problem of the neighboring right in both Germany and Spain, and now more broadly in Europe, is not whatever it does to Google, but what it does to everybody else. So I find it really interesting that apparently Australia is able to arrive at more or less the same conclusion as France as regards Google and Facebook through the instrument of competition law without touching copyright law at all, which means that all of the negative consequences for smaller platforms could be entirely avoided because they would not be subject to this competition instrument, as I understand it. So that I find very interesting. But I also want to say a little bit about Neil's counter proposals, because I think we all agree among the panelists that changing copyright law is not the answer. So what we should do instead. I very much agree with the proposal regarding taxing the advertising revenues. I think that makes a lot of sense because it has really, I think, displaced a lot of the profitability of quality news and shifted them to platforms. I'm a bit more skeptical regarding the prioritization of original reporting. We're having a similar discussion in Europe at the moment about whether or not to regulate the algorithms that basically decide what gets shown to you on news media. And I'm a bit skeptical about whether it would be possible as a legislator, and also from my experience having been a legislator, to basically legislate what the algorithm should prioritize. Because you're taking away basically the competition between different algorithmic approaches, and instead prescribing specific outcomes. Like you could write into the law, okay, original reporting should be prioritized. But of course, that has to be operationalized in some way. So for example, having taken a quick look at your draft, you could use the number of newspapers referring back to that original content as a proxy. But I think that could also create echo chambers, because the news media tend to, well, they're more likely to refer to the original source if the original source is an established newspaper. But there are particular groups of people who are much less likely to be attributed as the original source, especially women, for example. So I do think that requiring platforms to change their algorithms to surface original reporting could also reproduce some of the discrimination or the discriminatory tendencies that we see in the established media about deciding who is worth being accredited or attributed as the original source and who is not. And in the European context, we're actually discussing a different approach, because I do agree that at the moment, the platforms have no incentive to actually show users the most interesting content, but to show them whatever gives the biggest advertising revenue. And so instead of basically telling the platforms in the law what should be at the top of the feeds, there is the proposal that large platforms of a size similar to Facebook should be required to have an open application programming interface, which would mean that third parties, companies, news media themselves, but also NGOs would be able to provide Facebook's users with different versions of their feed that the users could pick and choose from. So this would mean that there would now be a competition over which newsfeed or which feed on social media gives users the best user experience, rather than a competition over which algorithm gives the biggest advertising revenues. So I have some reservations about this idea that we can really write into the law that the original sources should be highlighted the most. I think perhaps some platforms legitimately don't want to be used as a news distribution platform at all. And possibly that's also okay. I mean, I'm thinking more of some gaming platforms like Twitch that perhaps aren't anywhere near as large as Facebook, but perhaps legitimately are simply entertainment platforms and are not trying to be news distribution platforms. And I think that should be okay. And also when I'm searching something on Google, quite often I would say, if I'm looking at my own search terms, quite a lot of them are not about the news. I might be searching for a product, I might be searching for an institution or a person, and having a requirement that Google has to show original reporting about that search term might not be the most relevant for the user. So I would rather focus on breaking this dynamic that we have today, that platforms prioritize not the user experience, but the advertiser interests, by giving the users more control, by basically requiring large platforms to allow third parties to make different algorithms that the users can then choose from.
Mio?
Okay, yeah.
Do you want to make your comments, answer that, and also make the comments you'd like to make to the other panelists? There's a question directed to you, but we can make that later.
Okay, yeah, those are great comments. I really appreciate that. Yeah, I guess my sense is, I mean, as you seem to agree, that today there isn't much competition among the platforms for their algorithm. They're all focused on using persuasive technology to addict the users to remain on the platform as long as possible. So they all have the exact same approach. So yeah, I guess I'd be interested to learn more about the proposals to empower users. I'm not sure, the millions and millions of people on the platforms, I suspect it's a very small percentage of users that are sophisticated enough and thoughtful enough to be able to choose the difference and to be able, certainly to program, but even to know, which among these alternatives to choose. I still suspect that the default is going to be the platform's primary algorithm. So I'm not sure that it might benefit some users. I just have a question as to whether or not that really serves the purpose of providing more support for the news media, which I think is really critical today. I mean, I do agree. Also, I think it's a great point about the difficulty of legislation in this area and trying to define what is original reporting and to try to avoid untoward effects, biases, and the like. I guess I don't think it's an entire. It's a partial response to that. To that point, which is, I guess I would favor some kind of regulation by an administrative body rather than legislation to do that work, because the regulator can change the regulation more rapidly as technology develops. The legislatures are just probably more clumsy in that regard. But again, thank you for the comments. And I'd like to learn more about the proposal in Germany or in Europe, I guess, to empower the users to develop the alternative algorithms. I guess I just have a question to Rob. You prefaced your remarks, Rob, by saying that you don't believe that competition law can provide the solution. There's actually a short part of my article where I say that also, but I'm not a competition law expert, so I'd be very interested to hear from you. Do you think that generally competition law cannot provide the answer, or the specific proposals on the table in Australia cannot provide the answer?
Thanks, Neil. Yes, Rob, if you want to answer that. Another question that I had that I think refers to that is how that solution, if you can give more details on how that solution could address the issue of not empowering more the major media outlets, which I see is a problem that all of you are concerned with. So if you can give more details on how the code addresses that.
Okay. So first, thanks very much. I'll try and answer a few of the questions. I also was really interested to hear Julia talking about starting in 2009. I'd have to say that here the issues were not really recognized until at least 8 years after that. There is a problem that flows from the code, which is that there is an argument mainly put by Facebook and Google that says, well, why do we need a code that props up Rupert Murdoch's News Corporation? And that's perhaps one of the difficult issues with using a relatively blunt tool of mandatory code to deal with things. I'll go to Neil's question. I actually think the competition law does work here. My point was that competition law doesn't protect competitors, it protects competition. And the argument here is that there's an imbalance in bargaining power, and that imbalance means that there is a failure for competition to be able to flow. Now, Julia asked the question, is this based entirely on competition law? And the answer is yes, absolutely. And And there are a couple of reasons for that. The most important one is probably a cultural one, which is specific to Australia. In Australia, both consumer protection and competition law are enforced by a single regulator, the ACCC. That regulator is probably one of the most trusted by both, really oddly, by both the public and by politicians as a safe pair of hands to address a problem. And that has meant that difficult problems, wicked problems, tend to get thrown to the ACCC and say, can you find a competition law angle to this and fix it for us? And in the main, the ACCC has actually responded well to that. I really like Julia's API requirement. I've done some work in the past with Chris Marsden from the University of Sussex looking at interconnection of platforms as a competition intervention, because it's a relatively painless competition intervention. And I think, although Neil mentioned that users aren't going to be necessarily as sophisticated as to use the API, in my view, very much with the competition hat on, that doesn't matter, because what the API requirement creates is the opportunity for alternative intermediaries to enter to help users choose the news feeds that they want. So having an appropriate API can do that, and requiring an API is not a major imposition. One of the big problems that I have with Neil's proposal, particularly on where having a requirement on the operation of the business of each of Facebook and News, is that in the Australian context, I can only really talk from that Australian context, imposing those obligations would in effect require platforms to be licensed. And they're not required to be licensed currently. And that change from open competition to a requirement for a license could be argued to be a regulatory taking. Now, under the Australian Constitution, such a regulatory taking might require the government to provide compensation for any losses that are incurred. So in effect, what you'd end up with is state payments to Facebook and Google in order to require them to deal with an algorithm in a particular way. And that's why there's been a construction in the code which says not you must operate your algorithm in a particular way, but if you're going to change what you do currently, you have to tell the news media businesses. I think that there are tax solutions, and I like the idea of a tax solution, but I think it has to be something other than a percentage of revenue. The percentage of revenue works because there's no other tax point to tax. That is, it's very hard to find the profits of either Google and Facebook because they're somewhere between Ireland and Amsterdam. So some countries have got a diverted profits tax, like Australia and the UK, but any tax on revenue, which is a straight percentage of revenue, is always going to be argued to be a deadweight tax and inefficient. So I think it would need to be argued that the percentage of revenue is merely, and in the same way that that Julia mentioned France did, the percentage of revenue is chosen as a proxy for a percentage of profit because profits are diverted. And my final point, and then I will hand back, is I think the question as to what is investigative journalism was actually looked at by, as I say, a competition authority, and the ACCC was concerned that the declining number of professional journalists focusing on Australian news and this led to a reduction in certain forms of reporting beneficial to society, particularly public interest journalism, which the ACCC defined as journalism that performs a critical role in the effective functioning of democracy at all levels of government and society. And consistent with Neil's approach, it said that that's at a local court, a local government, a regional, at state and national level, and is important in exposing corruption, holding governments to account, holding corporations to account and individuals to account, as well as in the production and dissemination of knowledge. Thanks.
Thanks, Rob. Julia, Neil, do you want to address any of Rob's comments?
Yeah, so on this issue of the definition of investigative journalism, and I've seen a number of definitions. People in the industry or scholars who study this, come up with various definitions. I mean, the one I like the most is that investigative journalism seeks to reveal something that someone in power tries to keep secret, right? So that someone in power could be government, it could be corporation, it could be anyone really. And you could also add the focus should be on public affairs reporting as opposed to gossip reporting or something of that nature. Rob, I had a question that you mentioned. I don't want to get too deeply into the weeds of Australian law, but you mentioned the requirement to be licensed. I'm not familiar with any requirement like that in the United States. In the United States, the possible objection to my proposals would be a First Amendment objection, that the government would be requiring the platforms to speak in some way, which I don't think is right, but that would be the way it would be framed. I'm not sure what you mean by requirement to be licensed.
Well, basically, it's a very similar approach. So essentially, in Australia, if you want to run your business, and as long as your business is within the law, go do it. The government at any level can only impose conditions on the way that you run that business, either through law or by requiring that type of business, that class of business, has to be licensed. So if you want to be a commercial broadcaster, you need a commercial broadcasting license. Mm-hmm. That imposes conditions on commercial broadcasters. Platforms are not required to be licensed. And so the shift from the shift that would allow a government to tell a business how it must operate could only be done by putting it into a licensing regime.
I see. Thank you.
So I think the tax just has a much more elegant mechanism for who would fall under this law or not. I think you were saying the tax would apply only to Google, Facebook, and Amazon because only they have a significantly large share of the market in digital advertising. And I guess no similar elegant cutoff point exists for the requirement on prioritizing original reporting. I mean, I think clearly the requirement wouldn't apply to all platforms, right?
Right. I put it in I left it open. Basically I'm proposing regulation that a regulatory agency would regulate, and the agency would only apply to major platforms. I'm not sure what exactly that would be. It could change from time to time, but I would kind of propose that generally and leave it to the regulator to determine what is a major platform.
Mm. Yeah, I just wanted to make one comment on the APIs. I think indeed, Rob is right that the users would not be the ones using the API, but rather companies that could provide different user experiences as a service. So for example, a conglomerate of newspapers could get together and make such a prioritizing original reporting algorithm and offer that to users. And if the users like it, they would use it. But I think you're still right that most users are going to stick to whatever is the default, which is why in European data protection law, there is actually quite a lot of thinking about the default, like privacy by default, for example, where internet browsers would be required to be configured in a privacy-friendly way, so that you would ensure that users have to actively opt in. And you could do the same for large platforms. You could say by default, the timeline is chronological, like you're following 100 people and whoever has posted something last is who shows up first in your feed. And then if you want to change that, the user has to make an active decision to do so. So they can opt into the algorithm offered by Facebook, but they can also opt into the one offered by Reporters Without Borders, let's say. So that's the idea. This proposal is being debated in Europe in the context of the Digital Services Act. So there's no legislative proposal yet, but there is a parliamentary report, which is basically asking the European Commission to make a proposal, which they're probably going to do in December. And in that report, this requirement to open the APIs is included.
Very interesting.
And once you get to opening APIs, or in a world down here where data protection isn't as strongly enforced as other consumer protections, things like having private browsing, which Google offers with Chrome, and then doesn't necessarily respect all of the privacy. The action, which is currently on foot being taken by the ACCC, is for misleading and deceptive conduct by Google in failing to ensure that the privacy that the consumer would expect by clicking on private browsing is actually available. So Australia makes competition and consumer law work very, very hard, partly because other protections aren't as clearly defined, so we don't have a GDPR. But
that's maybe why publishers turn to copyright to solve all their problems, because it's very strongly enforceable and is being used for all kinds of things that have nothing to do with copyright law.
You know, since both of you have mentioned privacy in the GDPR, I just want to ask, I've heard, I don't know, I've read somewhere that some people believe that increased protection, more rigorous protection of the GDPR would actually ultimately redound to the benefit of the largest platforms, because they're more easily able to adapt to it. They have much stronger bargaining position vis-a-vis their users. So do you have any sense of that? Or do you agree with that? Or
I don't agree with it in principle. I think there is some merit to this argument if you only conceptualize data protection through consent, because it is much easier for Google or Facebook to get a user's consent. Like, let's say in the case of Google, if I am late for a meeting and I have to very urgently use Google Maps to get to where I need to go, and this is when they ask me for consenting to whatever, I'm very likely to just click through it. So the more kind of integrated a platform is, the easier it is to get consent. I think what makes the GDPR so strong is that basically it conceptualizes data protection as a personality right and not as a commodity. So you cannot pay with your data, so to speak, in under European copyright law. So this means you can always withdraw consent to the processing of your data at any time, and you cannot be offered something in exchange for giving your data. So there's a decoupling to ensure that the giving of consent is truly free. And I think those mechanisms actually really do not benefit Google and Facebook if they were properly enforced. And I think the proper enforcement is the part that is missing at the moment. But there are, of course, some organizations like Max Schrem's organization, NOYB, and also my organization that are kind of, working on enforcement of fundamental rights in the courts and with the regulators. And this hasn't really happened yet. So at the moment, it's relatively easy for Google or Facebook not to get fined under the GDPR because a lot of the litigation is still ongoing. But I don't think that it will ultimately stay that way.
And Google and Facebook could easily offer something to their users, make it sufficiently attractive for the users not to opt to not letting their data be used.
See, that's the thing with the principle of decoupling. Like, they can't give you something in return for consent.
I see.
So I think this is a really important issue. So in Australia, the idea of consent is very similar: freely given, express, informed, purpose and time limited, and easily withdrawn. And we're struggling with the decoupling at the moment. So the issue is, do you say that personal data has some sort of property right associated with it, in which case it's freely tradable, and you could decide, yeah, no, that meeting is so important that giving away my entire history and my iPhone to Google is worth it, so I get there. Or if you take that strict decoupling, which I think is a really important part of the GDPR, and it ultimately will end up with in Australia, where we're looking at how do we get to GDPR light? That is the bits that work without with the learnings of things that don't work so well, including, Neil, your point of, well, if the platforms get the most benefit out of it, has it failed or not failed? Has it not worked the way that it was expected? When the GDPR is really a right, it's something which could be a right which is created in other parts of the world and already starts to work in other parts of the world. GDPR is extra jurisdictional. So if I'm in Australia and I have Julia as a customer in Germany, essentially my treatment of Julia's data has to be GDPR compliant. So let's not have two schemes. We'll have a GDPR compliant scheme applying to all of our customers, even though the other 3 million might all be in Australia and Thailand. So GDPR is actually, it's a very significant right that's extending essentially through extrajudicial approaches in order for businesses to trade with Europe.
Which works well as long as nobody passes a contradictory law somewhere else.
So I'm mindful of time. We have a hard stop in 8 minutes. But I wanted to go back quickly to something that Julia mentioned right before, when she said, well, maybe that's the reason why publishers are going after copyright, because it's so easily enforceable. And I gather from this panel that no one thinks copyright is the best solution for this. Still, the copyright directive is being implemented in the EU countries, and this solution is being discussed in other places, such as in Brazil. And I feel that Neil's proposals, they relate to other proposals which are being discussed for other sectors as well. I think you mentioned that, other people mentioned that too. For example, in the film sector, there are discussions like that in Brazil as well, of like taxing, streaming platforms to also foster local production. But those solutions seem to be less palatable, right? It's harder to perhaps convince stakeholders because of what Julia was saying, and because it's harder to gather support. So thinking practically, how to go to that direction, which do you think are the best arguments to convince that the copyright, the neighboring rights solution isn't the best solution when you have other options on the table? If you can address that quickly.
Sure. I'll start perhaps. I don't think that Neil's proposals are somehow inherently less palatable. I just think that a few quite large and actually quite financially well-off newspapers have just spent a lot of time and money lobbying for the neighboring right as the solution. And this is why this idea has gotten so much traction. And I think it's important to point out that the neighboring right is not just ineffective, but it's actually extremely dangerous. It is driving not just small news aggregators out of business. Several news aggregators in Germany that were experimenting with innovative business models of bringing news to users have had to shut down because they were just not able to pay the license fees, nor to enter any kind of long-term litigation with the publishers. And it has been extremely harmful to smaller newspapers because fewer news aggregators means fewer possibilities for the brands that are not well known to actually make their way to readers. But I think perhaps in the current situation, if you're, so if this is being presented in Brazil as a measure against disinformation, that is something that is actually really easy to debunk. I mean, I'm not entirely sure how exactly the argument goes that this should somehow combat disinformation, aside from the very simplistic argument that this will bring money into the coffers of news media, because quite clearly introducing an exclusive right in copyright introduces friction. It makes it harder to link to those news articles. But of course, all the disinformation is not going to enforce this neighboring right. So it will be easy to link to disinformation, and it will be hard to link to quality information. And of course, it's not that there's necessarily more disinformation out there than there used to be, but that it's being surfaced on those platforms. So if you're actually making it easier to distribute disinformation because they are not going to charge for the neighboring right, and you're actually making the problem worse. So if this is the context in which this is being presented, I think that would be the main argument that I would push, that it's actually likely to be counterproductive for the disinformation issue.
One of the threat from Facebook to stop essentially linking to news is Facebook essentially agreeing with your proposition, I think, Julia, that the threat is not, oh, well, lots of users of Facebook will no longer have access to the news services that they love, but rather that the alternative disinformation and misinformation. So if the news that you get from Facebook comes from 4chan and QAnon, well, that's a pretty horrible outcome. It's fairly horrible for Facebook because there's the potential for users not to want to stay with that platform. But overall, the same risk of the implementation of the neighbouring right arises in Australia with the implementation of a competition law-based mandatory code, that if the exit strategy of one of the big players is, well, if we can't supply the news in the way that the quality news in the way that we want, the only news will be disinformation and misinformation. That's a fairly big threat, and it's a fairly effective lobbying threat.
Yeah, I also think that if you actually look at the market value, even for the large news publishers, as Julia said, they have a much greater interest in having their content on the social media than the social media have in having the news articles. So, I think, under the Australian proposal, it goes to arbitration, right? Some kind of binding arbitration. And now it could be the arbitrator is just going to affect some kind of redistribution of revenue from one to the other for kind of political reasons. But I think if the arbitrator were really looking at the economics of it, I don't think it's worth very much, right? The ability of the platforms to actually carry this content. It's a very small part of their overall content and revenue.
Yeah, and ultimately, it is a symbiotic relationship. Whether the net value flow probably is from the creators of news content to the platforms, but the net is very, very small, and that's part of the arbitration. The reason it's baseball determination, a final offer arbitration, is to try and force the parties to actually think about what the value is from each side and the risk. So the arbitrator can't actually choose something other than one of the two proposals put before the arbitrator, and therefore there is a risk for either party that the arbitrator chooses the other, and it's designed to get to a negotiated outcome which actually reflects the economic value of the interchange between the two.
Right. So if you're
I think it's actually more complicated than that. I think if you're talking about large publishers, you're probably right that both sides benefit. Probably the platforms benefit a bit more. But when you're talking about small publishers, it's completely the opposite. Because when we had the discussion over the neighboring right in Europe, a bunch of German news media started to share data about where their users come from. And you could see with the largest brands, something like 70% of the traffic was direct traffic, people going directly to the homepage. And in the case of small media, it was something like 20%. So for them, actually being on social media, being on news aggregators is absolutely vital. So for them, it's a much bigger benefit to be on there than the platforms benefit. And that is really my fear, that if you say, actually, it's a net benefit to the platforms and they should pay for it, they might just decide to cut out the small media that they're really not interested in, and they completely lose their economic basis. So it will really lead to media concentration.
And there are two aspects of the Australian Code that try to address that. One is to allow collective bargaining, which is intended to be regional newspapers working together. And the second is to have a non-discrimination provision that says Google mustn't treat a small regional newspaper in a way that is significantly different from the way that it treats News Corporation or one of the other large media players. But it's only a hope rather than it hasn't yet been implemented, but that's the intention.
So unless anyone has anything pressing to say, I'd finish this panel here, which was extremely rich. Thank you all so much. I'd like to especially thank Rob, who's speaking in the middle of the night. This was really nice of you. Thank you all. This is being recorded, so it will be made available. I think this is a great resource for this discussion. I've learned so much. And we'll keep in touch.
Great. Thank you.
Thank you.
Thank you so much.
Bye-bye.
Bye.